All right, welcome to The Explainer. Now, if you're gearing up for the Queensland bar exams, there's one section of the Constitution you've just got to know inside and out. I'm talking about Section 58. It's more than just a few lines of text, it's the ultimate constitutional safety net for the rule of law in our state. So let's start with a classic legal puzzle, one that really gets to the core of what we do. Can a parliament create some kind of tribunal or decision maker and then just pass a law saying its decisions are completely final? No appeals, no reviews, end of story. It's a huge question about power and accountability, and in Queensland, the answer is way more interesting than you might think. And the answer really begins with Section 58. Think of this provision as placing the Queensland Supreme Court right at the very top of the pyramid. It's what gives the court the muscle to act as the ultimate check on government power and decisions. Okay, so here's the text itself. Now, at first glance, it seems pretty straightforward, right? It's just declaring what the court is. But the real magic isn't just in what these words say, but in what they protect. This language confirms the court's huge authority, but its true power, its constitutional shield, only really comes to life when you read it alongside a key High Court decision, which we'll get to in a moment. So to really appreciate how strong this section is, we need to pull it apart. There are three absolutely crucial phrases in here, and each one stacks on top of the other to build this incredible fortress of judicial power. Let's start with the first one, all jurisdiction necessary for the administration of justice. This is a huge, sweeping statement. We're not just talking about hearing trials. This gives the court the power to oversee the entire legal system in the state, from the magistrate's court right up to various tribunals. It's the source of its power to make sure justice is actually being served.
Second, it's a superior court of record. Now, this is a really big deal. It means the court's own records are treated as gospel. They're conclusive. But the most critical part for you as a future barrister is that its jurisdiction is presumed. The starting point is that the court can hear a matter unless a valid law very clearly says it can't. It completely flips the burden.
And finally, we have unlimited jurisdiction. This basically makes the Supreme Court the default go-to court for any legal problem you could possibly imagine, covering both law and equity. The only hard stop, the only real limit, is the Australian Constitution. And as we're about to see, that Constitution actually ends up being its greatest protector. So this brings us back to that big question from the start. If Parliament can just pass laws to strip away jurisdiction, what's stopping them? How is the Supreme Court's power actually protected? Well, this is where a total game-changer of a High Court case comes into play, giving Section 58 some serious constitutional teeth. And that case is Kirk v. Industrial Court of New South Wales. This 2010 decision absolutely changed everything for state Supreme Courts across Australia. What it did was identify a core and irreducible minimum of their power that is constitutionally protected, and that no state parliament can legislate away. So how exactly did the High Court do this? Well, the logic, which we now call the Kirk Doctrine, flows in three simple steps. 1. You can't read a state constitution in a bubble. It has to fit within the bigger Australian Constitution. 2. That Australian Constitution in Chapter 3 sets up an integrated national court system that depends on each state having a Supreme Court at the top. And 3, this is the knockout blow. Because of that, a state parliament simply cannot pass a law that guts the essential supervisory job of its Supreme Court. That core power to step in and fix fundamental legal mistakes, what we call jurisdictional errors, is now entrenched. It's untouchable. Okay, so what does this constitutional backstop actually look like when the rubber hits the road? Let's check out how Queensland courts have used Section 58, now supercharged by Kirk, to deal with real-world legal fights. This is where you see the theory slam into practice. Just look at the pattern in these Queensland cases. In Northfield, a law tried to block the court from reviewing building adjudication decisions. The court said, no, you can't. Our power to review for jurisdictional error is irreducible. Sam Dillon, N.K. Collins, an industrial court decision was thrown out because of a fundamental flaw. But, and this is the part you really have to lock in, look at Bauer Foundations. The court refused to get involved. Why? Because the mistake there was an error of fact made within the tribunal's power. It wasn't a jurisdictional error. Getting that distinction right is everything in practice. So let's boil it all down. For your bar exams, and definitely for your career, what's the bottom line here? What do you need to have ready in your head when a client walks in with a decision that some law says is supposed to be final?
Okay, here's your toolkit. Number 1, and this is the big one, judicial review for jurisdictional error is always an option. I don't care if a statute screams that a decision is final. That can't block this. 2, don't forget that Section 58 is also the basis for all those flexible remedies like declarations and injunctions. 3, the Supreme Court's reach is wide. It can even hear matters about Commonwealth laws, as long as it's not stepping into exclusive federal territory. And finally, it all comes back to that one crucial distinction you'll be arguing about in court. Was the mistake a reviewable jurisdictional error or just a simple, unreviewable error made within jurisdiction?
And that really leaves us with the million-dollar question for your study. We know, thanks to Kirk, that the door to the courthouse can't be locked. But the entire fight, almost every single time, is going to be about where that precise line is drawn. Understanding that line, arguing that line, that is the key to absolutely mastering administrative law and having a successful career at the Queensland Bar.